Hi everyone, my name is Tom Marchese and I'm a workers' compensation partner with Chartwell Law. I'm in Tallahassee, Florida, although the firm provides statewide coverage. I handle the northern part of the state for the firm. We want to do this video today just to provide some information to you guys. We've been posting a lot of relevant information regarding the COVID virus to our website. A lot of articles have been written by the lawyers of the firm. And a lot of position papers we've been putting up there. But we wanted to do a little something different. First of all, we wanted to reach out and check with all our friends and clients, make sure you're doing well out there in these trying times. Things are changing, things are different for everybody. And so we're trying to adapt with the times. So we hope you're doing well and staying safe. I'm here today with my partner, Mitteer Bartley. Amanda handles the southwest portion of Florida for us. And we just want to provide you some information on some of the changes we're seeing in the Florida workers' compensation law as it relates to the COVID virus.
I'm Mitteer Bartley. As Tom said, I'm down in Southwest Florida. We hope everyone's doing okay, especially those of you who are balancing working at home while also helping your children learn remotely. Tom and I are going to discuss how COVID-19 is affecting Florida workers' compensation claims, especially given Governor Ron Desantis' ongoing stay-at-home order in effect until at least April 30th.
Yeah, and if you haven't done so already, or if you haven't seen these cases rolling in, we would expect that you probably will, fairly likely. And the biggest question that we've been asked, obviously, is are these cases compensable under Florida workers' compensation law? And it'd be fun to give you a pat answer, a single sentence answer, but we can't do it. To be honest with you, they could be, and each case is going to hold a particular analysis that you're going to have to go through on a case-by-case basis. The cases that are presented are going to be under an occupational disease theory, which is governed by Section 44151. And the things you're going to have to look at, or the analysis that we're going to have to go through, is first, the disease must actually be caused by the employment conditions, must actually be contracted during the employment, and the occupation must present a particular hazard that's not out there to the general public. Or alternatively, the incidence of the disease could be greater within that particular employment. And some of the things that obviously pop to mind first are first responders, frontline doctors, frontline nurses, EMT techs, ambulance workers. Some of the things you might not think of, but we're seeing quite a lot of, are grocery store workers, people that are there serving the general public as we get our daily groceries. You know, a lot of different stores are implementing protective measures, but still, these people that work in the grocery stores, they're in there day in, day out, exposed to the general public. So those are things you have to look out for. And sort of the analysis that we're going through is, what is the evidence that a claimant can use to prove they contracted COVID on the job site? Well, first of all, they're going to have medical evidence that they actually have the virus. And then they're going to have some type of statistical or documentary evidence showing that the incidence in their particular profession is in fact higher than the general population. Not an easy burden, but also one that we think the courts are going to be fairly liberal in interpreting. And another consideration is, how are you going to establish this proof given the fact that this virus can stay dormant in your system without symptoms for up to 2 weeks? It's a really new field that we're going into, and we're doing everything we can to stay on the forefront of it, stay on the cutting edge of it, to do our research, talk to doctors about ways to defend these matters. But it's going to be a developing field, and that's what we wanted to talk to you about today.
That's right. Under a recent directive from Florida's Chief Financial Officer, Jimmy Petronas, Florida state employees who are paid by the state and are working on the front lines of the coronavirus pandemic are eligible to receive workers' compensation benefits. But this only applies to state-paid law enforcement officers, EMTs, correctional officers, healthcare workers, child safety investigators, and the Florida National Guard members. At this time, this has not been extended to municipalities and county workers. On all other cases, you're going to want to investigate the claims on a case-by-case basis.
Yeah, thanks, Amanda. And we're posting a lot of this information on our website as well, as I mentioned when we first started talking. So we'd like to refer you there as a reference. But some of the things that are relevant inquiries if you do get one of these cases, and one of the steps that you certainly have to go through is you have to ask yourself a number of questions that you wouldn't otherwise ask perhaps in a normal workers' compensation claim. You have to look into specifically what was the employee's job title and description. Did they come into contact with a greater amount of people than perhaps other certain jobs in the area? Was the employee at the time supposed to be working remotely or at home given the stay-at-home order, and was he or she out there doing something other than their job duties when perhaps they contracted the virus? Was the employee provided with any form of PPE or protective gear, such as masks or gloves, anything along those lines? Those are all really relevant areas of inquiry for these types of claims.
Additionally, you want to find out, when did the employee first notice symptoms and what types of symptoms did the employee have? Did the employee seek medical treatment and test positive for COVID-19? If so, when and where? Is there written confirmation of this positive COVID-19 test? You'll also need to further investigate whether the claimant could have been exposed elsewhere to COVID-19. Find out, did the employee travel outside of the area 14 days prior to the diagnosis? Did the employee attend any social gatherings 14 days prior, like at a church or a birthday party? How many people visited the employee's household in the 14 days prior to the diagnosis? Was there a babysitter coming to the house? Did they have a grocery delivery service or have pizza delivered? Did anyone else in the employee's household test positive for COVID-19?
Yeah, absolutely. So the theme here that I think you all can see is that these are very fact-specific types of inquiries and cases that you're going to be dealing with. Going even further beyond what Amanda said, you look into where the employee might have been for the 14 days prior to the diagnosis. Did they leave the house, go to a supermarket, gas station, public space, restaurants, even for takeout? Food delivery is another one. Obviously, a lot of people are getting food delivered. Was that person tested, the food delivery person? Amazon packages. They've proven that this virus can last on paper and plastic products for up to 24 to 48 hours now. All these things are really relevant. What was the claimant using in his or her own home as protective measures? Were they using antibacterial wipes? Were they using antibacterial soaps? Were they using masks whenever they went anywhere anywhere outside of their home? Did they come in contact with anyone else who tested positive in the 14 days prior to the onset of their symptoms? All these things are going to need to be cataloged, and they need to be done early on in the claim when the initial investigation is done. That's really what we're trying to stress, is not only are these things different, but they have an increased level of scrutiny right when you get them in the door. And so we wanted to make you aware of that and just bring some of the relevant questions that you'll need to ask the claimant today.
And then unfortunately, COVID-19 is going to affect our current workers' compensation claims. There may be situations where a claimant is off work and a medical provider is not seeing patients at this time. You'll want to ask that medical provider whether they are providing telehealth sessions for their patients.
Yeah, absolutely. And we're seeing more and more of this, quite frankly, and this is my personal opinion. I think it's going to be the new meta. I think we're going to see a real level of increased telemedicine because of this. And I think this has forced a lot of doctors, perhaps even hospitals and things, to embrace telemedicine when they might have been holding off otherwise. So if you can't get a telemedicine appointment, or the doctor doesn't offer them for whatever reason, it becomes incumbent upon us, I think, to reach out to the doctor's office or whoever the treating provider is and ask for a DWC-25, possibly updating work restrictions. The obligations under the statute aren't suspended because we have a COVID case. So if in fact, we can't get back to the claimant can't get back to the doctor for an updated work status, we need to reach out to the doctor himself and find out if anything's changed.
Going forward, there will be situations where the claimant may be seeking TPD benefits and saying the employer did not have light duty work available because of the pandemic. You want to confirm with the employer that but for the pandemic, work would have been available within their restrictions. Remember, the statute requires wage loss to be related to the underlying industrial accident. If an employee, on the other hand, refuses to return to work for fear of catching the coronavirus, you'll want to assert that this is not a fear related to the industrial accident.
Exactly. We wish we could provide you a clear-cut answer, Jay, but there just is none at this point. Each case is going to be a case-by-case analysis involving what the employee did, who the employee came in contact with, what safety measures were employed. Obviously, the positive test results super important, and those things have been delayed too. So everyone's a case of first impression right now. But my partners and I, Amanda included, we've been discussing what we think is going to happen. Quite frankly, we think that the legislature is going to take the decision-making analysis out of our hands. It hasn't happened yet, but I know there's been 16 states already who has introduced legislation which has affected or changed the burden of proof on COVID cases. So essentially, the states are loosening the burden of proof. We expect Florida will likely follow suit. Hasn't done so yet. Getting ready for this meeting, I did a legislative search yesterday, and there's no pending bills up there. But in speaking to people involved in the legislature, it's, as you might expect, certainly a hot topic. And we expect something to be introduced fairly soon. But as of right now, we wanted to go through our analysis in how we're going to evaluate these COVID cases, and it's valid as of right now. On an interesting side note, the first wrongful death suit that I'm aware of was filed in Illinois, actually. The suit alleges that the employer, and I won't name them at this point, acted in a willful and wanton manner by not providing PPE or safety gear to their employees. And by so alleging, and I don't know if it's going to be successful, they're bringing it outside of the exclusive remedy provision of the workers' compensation system, basically alleging that the employer engaged in a intentional tort, so to speak. And so they're going to file a wrongful death case. And it's going to be a while before that gets anywhere in the courts. But I wanted to make you aware of it because this is going to be a hot topic, a hot button area of litigation for quite some time, we think. We're not done with this virus. We're not done with the quarantine, although some restrictions are being loosened. But I think we're going to see this litigation for quite a while. Anyways, we wanted to be brief. I hope we did so. We wanted to be informative. I hope we were that as well. But mainly, we just wanted to say hi to all you. We miss interacting with everybody. We hope you're staying safe. And if there's anything we can do to help, you can reach out to Amanda or myself, any of the partners in Florida. All that information is available on the website. And we wish you the best and look forward to continuing to work with you.
Thanks for tuning in.